Welcome back. I guess we have an hour and a half to complete the session. Based on the experience of the previous session, we can easily say that there's so much interest in the topic that there will be temptation on both sides, to the presenters and to the audience out there also, to be longer than the time that's been allocated for us. But lucky we are that immediately following this session will be lunch, I guess, right? So we can just, if we do not get to ask a question, don't be mad at me. You can go catch the speaker and ask him the question. So I don't want to take longer than I need to. I mean, speakers have already been introduced. So I'll directly go to the first speaker and would like to request Dr. Shiva Kumar Giri to present his paper on economic constitution, federalism, some inherent problems and practical solutions in Nepali context. But before I before I yield the floor to him, I would like to point out this. I mean, the management organizing committee has told me that whenever you are asked to make an intervention, or speakers when they make their intervention, either speak only in English or only in Nepali. Nepali bolne manchele Nepali matre bolidinu hola, Angrezi bolnele Angrezi matre bolidinu hola, because translators, I mean, they have a hell of a time. They do not know whether this should be translating from English to Nepali or Nepali to English if you switch in between. So make sure that you want to speak in one language and stick to that language. Now over to you, Dr. Shiva Giri, and you have exactly 15 minutes. And I'll be very, very particular about that.
Yeah, it is good to have a management expert as a chair. So thank you very much, Chair. I will try to be as precise as possible, and I'll try to finish my presentation within 15 minutes. My paper is on economic constitution, and I'll be focusing more on the economics of federalism. It is actually work in progress, means I have yet to do a lot of things. So there are two parts in this paper. First part presents the theoretical underpinning, or let us say approach of analysis that I am using to understand and solve certain problems actually identified by many participants that we are hearing from yesterday. So first let me introduce the approach. The approach is called law and economics. Sometimes it's called economic analysis of law. So what does it mean? It uses economic principles, tools, ideas, concept to understand legal rules and problems. So a constitution is, usually called a political document or social document. But the economic analysis of law, or the scholars of law and economics, consider constitution as an economic document. So economics has certain tools to analyze issues such as incentives, positive and negative, and analyzing performance on the basis of certain concepts such as efficiency. And the audience who is familiar with the economic parlance, they may know the concept of Pareto efficiency, or Kaldrick's efficiency, or welfare efficiency. So using the economic tools, this paper will try to understand some of the problems identified while implementing constitutional provisions, especially the provisions relating to federalism. So because of the time constraint, the paper is, I think, available to you. The majority of the paper actually introduces the conceptual approach that is going to be used to analyze the problem. So I'm not going to concentrate more on that. I'll just introduce few themes. So what economic analysis of law does, it looks the law as a economic concept. So we have a constitution. Why we have constitution? Because it wants to fulfill certain economic objectives. The objectives may be, some, let us say, normative. So it doesn't question the normative precepts. It just analyzes the precepts on the basis of what is available, what is offered, and how it is performed. So our objective may be, let us say, for our discussion, let us use the example of federalism. Why we needed federalism? So the armchair researchers, researching at home will say, okay, people need recognition for their identity, this and that. But the economics always uses empirical tools. It goes to the people and finds out, using scientific methods, why did you need federalism? What objective you wanted to serve? Once you have, of course, there are issues such as, the economists call the utility function, and then the second step is, of course, how to maximize that utility, and there are other issues such as equilibrium. So once you have the objectives with you, or economists use words such as preferences. So people want federalism. Some people want it because they wanted recognition of identity. Some want it because they felt they are marginalized. Some wanted, let us say, maybe they are not properly taken care of by the central government for whatever reason, for ethnicity, for language, for other. So once you have the objective, and then the people always try to, like a homo economicus, or a selfish, rational human being, always tries to maximize their happiness. But there is a limitation of resources, so they have to make choice. There is and the preferences must be ranked. So let us say if we wanted to have a identity-based federalism, how many ethnic population are there in Nepal? 110 or 103, I don't know exact data, but it's over 100. Can we have 100 federal units possible? Of course not. So they have to make a choice. But economics always, as I said, bases on certain testable variables. Professor Dr. Wagle in the previous session said, what is the rationale behind forming 7 provinces and assigning the geographical area that has been assigned? If we know the rationale, then we can test whether the powers given to them, whether the responsibilities assigned to them matches with the objectives. So here, this is the theme. Of course, because of time constraint, I'm not going to go in detail. It's in the paper. Now, how you can solve or understand, first we need to understand the problem of implementation of constitutions, or ambiguities in constitutions, or behavior. Remember, the economics is a behavioral science. So behavioral science in the sense that people behave in a particular way if they are given certain positive or negative incentives. So if, let us say, we make something cheaper, people will buy. If we make something expensive, people will not buy. The rational people are always do so. I'm not saying that economic analysis offers panacea, it is the best, it solves all the problem. No, it just offers an objective standard to look into certain problems. So federalism, if we look into the problems that have been identified, it was actually very illuminating for me as well while writing this paper. As I said, it's a work in progress. I heard so many complaints. Federal government doesn't want to give power. Bureaucracy is not supporting. The judiciary is not deciding the cases on time. Or if we apply economic approach, we need to understand what are the incentives, positive or negative, for the judges not to decide. Why some cases are decided so quickly within 2 weeks, fortnight, and some cases are pending for years. What incentive they have? Same question we can ask. what incentive there is for bureaucracy not to support the federalism or the federal process? Same question. And then let us find out the ways to change in that incentive pattern. Of course, we have to make choices. I already told you, we cannot always go for the best solution. That's why the economics offers Pareto efficiency, which is, the optimal efficiency. And then there is a lower version, which is called Calder-Hicks efficiency. So Pareto efficiency says if everyone is benefited and nobody suffers, that is the best option. But that is not always, that is not possible, maybe in utopia. So Calder-Hicks says that let us balance the cost and benefits. So if, let us say, cost is less than benefits, then that is efficient. So we need to find solution that is at least Calder-Hicks efficient. So now let me go into some of the problems identified by the participants, and also I see as a researcher in our federalism implementation process. Our federalism implementation, or our federalism, is very unique. There are hardly, I think, 2 dozen or a bit more than 2 dozen federal countries in the world. And most of them actually, these already autonomous separate constituents, they formed the federalism. So they already had, the government, policies, laws, so many aspirations. And then ultimately, they compromise. And economists know, there are different theories such as bargain theory to allocate the aspirations or manage aspirations. So Nepal's unique in the sense that we have no experience at all of implementing federalism. So we are very few countries who try to convert an unitary form of government into the federal form of government. So that presents a unique problem. The problem is, of course, because there is no experience, so everyone is a novice. Everyone is trying to think that, okay, this is the best way to do, let us do it. Some people who are enjoying power for, hundreds of years, they don't want to set the power. And if the constitutional norms, rules, designs, institutions we have created provide such incentive that they find it easy to, not implement federalism, then it is not going to work. Sometimes, to correct that, we need to change the constitution, but sometimes the court can interfere and provide that the change in the incentive structure. I want to use one example, the Indian example.
Less than 5 minutes left.
Yeah, I am also keeping one eye on the watch. The Indian example, I don't know, maybe the new generation might not have heard. The old generation has, seen many times. Whenever there was a change in the federal government in Delhi, they would just dissolve the parliament of provinces, even if the parliament might have been elected within 1 year or so. So what was the incentive there for the government? Because the structure was that the constitution gave that power, so they misuse it. When court put strict conditions, remember, without changing the constitution, the Supreme Court put strict conditions to do so. Now you don't hear, a party, ruling party in federal government dissolving the provincial government. Why? Because the court removed that incentive for the government, central government. So here, there are mechanisms. Of course, some mechanisms, because there are inherent problems in our constitutional design and structure. And I think Professor Wagle rightly said earlier that we didn't consider economic aspect at all. We were just thinking about, political, social, sometimes whimsical reasoning to form federal structures and also assigning powers. And even the discourse is a problem. The problem is related to, talking about powers only. We created institutions for duties. Governments do not have power. Governments have duties. They have power only to fulfill that duties. If you always talk about power, so you are treating yourself as if, the people doesn't matter. They elect you as their masters for 5 years, and for 5 years you can do anything. So remember, if there is any murmuring about the failure of federalism, from where it is coming? From people. But isn't the federalism is for the people? So what is the factor, or let us use the economic tools. What are the negative incentives the people are feeling from the performance of the federal structures, the provinces and local government? And a lot of people are giving example of local government, why we need to have federalism. But local government were there. Devolution of power is not federalism. It's a policy choice. Federalism is a constitutional choice. So we need to think about province, not the local government. Local government were already there. They were performing. Of course, we added some power, some responsibilities. And even if federalism is not there, there will be local bodies like many other countries. So we need to look into these incentives, positive and negative incentives, the duties that the local and provincial governments can perform. Because remember, once the responsibilities are there, then the central government needs to provide. They will not have any justification, any objective standard not to give the power. But if we just talk about power, it's just handing over the kingship from one person to another person. And I think if we don't change our outlook, if we don't change our approach, then the question will be there. So federalism is required for people. We need to understand people's aspiration empirically, testing in the field, not sitting in the armchair and thinking, okay, this is what people think. No, this is not going to work, and this is what the paper aspires to do. It's a work in progress. I am actually trying to understand and analyze several constitutional provisions using the law and economics approaches. Hopefully when it is available, it will be covered. Thank you very much for listening to me.
Now we move on to Professor Dr. Satya Arinanto of University of Indonesia. He will talk about Indonesian constitutional framework, problems and solutions. You have 15 minutes, Professor.
Thank you very much, distinguished guests, ladies and gentlemen. Good afternoon and namaste. Yeah. As you know from the program, I will present about the constitutional legal framework of equitable distribution of fiscal and state resources in Indonesia. Yeah, actually, I organize actually my presentation like this, but because of time constraint, maybe I will jump to section C or section D. Yeah, after this. This is the first section. That as you know, that Indonesia is one of the countries in Southeast Asia, yeah, which comprise more than 17,000 islands. Yeah, maybe around 6,000 islands were inhabited. As you see, the capital is Jakarta. That's the island in the island of Java, one of the biggest island. First of all, I will have a short intermezzo that between Nepal and Indonesia, there are some similarities. Yeah, if you go to my island, you will find the place that called Nepal Van Java. This is the Nepal atmosphere in the land of Java. Yeah. But yesterday when I arrived here, I also find the Himalayan Java coffee. Yeah, yeah. Yes. So it's Minister. Yeah. I will jump because time constraint. Yeah, this is the section C. This is about the constitutional foundation. Of course, this is the new constitution after the amendment, after the resignation of former President Suharto. Actually, we experience the unitary state. I will talk about the current first, yeah, because the current constitution using the unitary state, that's based on the Article 1, Paragraph 1, which stated that the state of Indonesia is a unitary state in the form of republic. And then this is the old constitution with some state institution, and this is the current constitution, yeah, in which you could see the line, that is the line between the central and local government. And there are some state institutions in the central and also in local government. And this is the distribution or separation of powers under the new constitution. The House of Representatives, yeah, shall have the power to make laws, and then the president shall hold the power of government. And then in the judiciary, we have two courts. Yeah. The first one is the Constitutional Court, and the second one, the Supreme Court. These courts are the independent power to maintain a system of courts with the objective of upholding law and justice. This is about the regional governments. It is regulated in Chapter 6 of the Constitution, which stated that the unitary state of the Republic of Indonesia is divided into provincial regions, and these provincial regions are divided into regencies and municipalities, whereby every one of those provinces, regencies, and municipalities has its regional government, which shall be regulated by law. Yeah. As you could see that the regional government comprises of head of regional government and the regional House of Representatives. They have some power, yeah. First, shall regulate and manage their own government affairs according to the principle of autonomy and duty of assistance. And then exercise widest autonomy, shift to government affairs determined by law of the affairs of the central government. And then entitled to determine regional regulation and other regulation for the execution of the autonomy and the duty of assistance. All head of local government and also the member of the regional House of Representatives are elected to a general election directly. This is still regarding the regional government, especially about the relation between the central and the local government. The Constitution stipulated there are two kinds of relation. First, the authority relation. Secondly, the financial relation. About the authority relation between the central and the local government of the provinces, regencies, and municipalities, or among the provinces and the municipalities, shall be regulated by laws by having regard to regional specificity and diversity. And secondly, the financial relation, public service, and the utilization of natural resources and other resources between the central government and the regional government shall be regulated and be executed justly and harmoniously by virtue of laws. Yeah. And then also the state shall recognize and respect units of regional government of specific and or special nature, which shall be regulated by laws. I forgot to translate this one, but this is also about the indigenous people, that state should also protect the indigenous people. This is about the national economy. Actually, this is also about the equitable distribution of state resources. Yeah. First, about the national economy, this is regulated in Article 33 of the new Constitution. First, shall be structured as a joint enterprise by virtue. And then production sector, important for the state and vital for the livelihood of the people at large, shall be controlled by the state. And then the land and waters and the natural wealth contained in it shall be controlled by the state and utilized for the optimal welfare for the people. And then shall be conducted by virtue of economic democracy under the principle of togetherness, efficiency with justice, sustainability, environment, insight, autonomy, as well as by safeguarding the balance of progress and national economic unity. And also this chapter regulates about the social justice. Yeah, but this is in Article 34, which says, among other, that the destitute people and neglected children shall be nurtured by the state, and the state shall develop a social security system for all the people and empower the poor and the incapable society in accordance with human dignity, and the state shall be responsible for the provision of decent health care facilities and public service facilities. Actually, we have also the past federal system. Yeah. In the past constitutional system, Indonesia has experienced the federal system, but only around 8 months. Yeah. Actually, from 27 December 1949 to 17 August 1950. This constitution, was the subsequent stages of Indonesian history, when the development of the young state of Republic of Indonesia at the time was undermined by the attempts of the Dutch to reinstate their power in Indonesia. Yeah. On 27 December 1949, the formal transfer of sovereignty from the Netherlands to the Republic of Indonesia, to the Republic of the United States of Indonesia at the time, because we became federal, took place. Yeah. The previously prepared provisional constitution of this newly created federal state immediately came into force. The Constitution of the United States of Indonesia, or the Federal Constitution of 1949, or the 1949 Constitution, which was the second Indonesian Constitution, provided for democratic procedure, the protection of human rights, and of course the division of power that was so essential for the functioning of the federation as a whole. Yeah. It had 197 articles in 6 main sections. Yeah. First, the state and the United States of Indonesia. Second, the United States of Indonesia and its component regions. Third, the instrument of state. Fourth, administration. Fifth, constitutional assembly. And sixth, amendment, transitional, and final provision. But the problem that many Indonesian founding fathers, they want to return to the unitary state. So after 8 months, we returned to the unitary state system on 17 August of 1950 at the time. What system now been implemented is the unitary state, but with, we call it asymmetric decentralization. Yeah. This is usually, happen after the Reformation era. Reformation era is began after the resignation of the former President Suharto on 20 May 1998. Yeah. I saw that Indonesia as a unitary state tends to apply to unitary state principle with asymmetric decentralization. There are 3 provinces out of the total 38 provinces which experience the practice of asymmetric decentralization. First is the province of Aceh. Yeah, as you know, maybe the province of Aceh full of conflicts. Yeah, since before Indonesian independence actually, because they have many kingdoms, and then it is continue when Indonesian independent, and they make Aceh free Aceh movement. Yeah, and finally there was a MOU in Helsinki in 2005. With some point, yeah, you could see in my paper that was distributed, and then based on the MOU, we make new law on number 11 of 2006 on the governing of Aceh. Secondly is the province of Yogyakarta, or as a special features regions. This is based on law number 13, 2012. But actually this law replaced the previous law, law number 3 of 1950, on special features of the province of Daerah Istimewa Yogyakarta, or Yogyakarta Special Features Region, which is located in the middle of Java. The third is the province of Papua. Yeah, this is based on law number 2 of 2001, but amended 2 times. The last time is by law number law number 2, 2001, and then amended 2 times, become law number 2, 2021. This is on special autonomy of the province of Papua. Similar with Aceh, we have also problem with the Papua. Yeah, maybe I can describe like some regions in UK or in Canada. Yeah, they want to separate from the country. So the problem is how to handle this in order to place them still in the context of the unitary state. So they need more equitable in state resources, yeah. Especially in Aceh law. They ask until 70%, yeah, for Aceh people. Not for, so the central government only 30% in some articles. So this is my conclusion, yeah. That we are a unitary state, but from the historical perspective, there were some eras when it applied federalism principles. First, as I told, during the 27 December of 1949 to 17 August 1950. Secondly, after the Reformation era. So actually, I see that the asymmetrical decentralization is the same with maybe more than federalism, in my opinion, yeah. But federalism in the context of unitary state, yeah, which we call asymmetrical decentralization, because theoretically there were 2 kinds of decentralization: the symmetrical decentralization and asymmetrical decentralization, yeah. But from the 3 laws which provide special features or autonomy for the 3 provinces, I saw that there are 1 law which regulate. Yeah, for me, this is an unequitable distribution of fiscal and state resources, i.e. the law number 11, 2006 on the governing of Aceh. Yeah, you could see some points, yeah. Okay, thank you very much for your kind attention. Okay.
With these 2 presentations, we have wealth of information about Indonesia and the context in which we federalize Nepal's governance. Now I will ask the both the commentators in a row to comment on either of those 2 papers. First, Mr. Dipendra, former Chief Attorney, Madhesh Province of Nepal. You have 10 minutes, sir.
Good morning. Thank you very much for these 2 important paper. I would like to start with Nepal 1, Shiva Kumarji paper. I definitely ask, because this paper is under developing phase, so I would recommend you to include the 4 sections in your paper. First, I think we have to look the political background of the federalism in Nepal. And you all know that federalism is not that is given in blessing or any kind of things. It is like we fought there, we got it with the sacrifice of 200 martyrs in Madhesh province particularly. So it has the strong political background. So I would like you to recognize that political background, that how it came. At that time, Prime Minister Girija Prasad Koirala was forced to amend Article 138 because of the movement. So that political movement, because the reason I mention it, when I was coming through this morning, on the street there was slogan, we have to undo with federalism. So there is a popular sentiment going on in Kathmandu particularly that federalism is not delivering up to the level of expectation of people. So we have to look it from why these questions have been raised at public arena. So please look at the political level as well. Second, I would also like to add in this paper the institutional and legal framework. I think there are lacuna with the current legal setup, already mentioned in earlier session as well. We have Intergovernmental Fiscal Arrangement Act, and I found there is a legal loopholes in section 6, section 7, and many sections particularly. Because if you look at that, in section 6, subsection 2, you can find that there is like a 70% of value-added tax and excise duty goes to the central government, whereas 15% goes to the provincial government, and 15% means 7 state is equal to 2% basically. So you have to do, and it's a large portion of tax basically, and 15% goes to the local bodies. Even in royalty, if you look at the section 7, you can find that 50% of total royalty goes to the central government, whereas 25% to the provincial and 25% to the local bodies. So, and also with the NNRFC Act, there is a legal lacuna there as well. You find that the formula set up by the NNRFC is like not rational in a way that it has given like a less priority to the many areas which I think has to decide on the base of the research and fact as well. Because Intergovernmental Fiscal Arrangement Act was made before the commission was formed, Natural Resource Fiscal Commission was formed. So it's preemptive law basically, and preemptive law has to be revised based on recommendation. But unfortunately, the commission, even I found in Achyut sir paper, that is completely bureaucratic setup. It's like a tiger without teeth. Like it has no power to recommend for amendment of the law with the government. So I think looking at the regional, even I would like to re-emphasize, looking at the regional experience, even in Pakistan in Article 160, that as you mentioned in the paper, you have National Finance Commission. And I find that more or less we have similar trend that our commission are not autonomous in a way. Our commission are not like strong enough to recommend to the government, okay, look, there are defects in these laws, please amend them. So I think we need similar condition in Nepal as well. So I think first, all the preemptive law should be revised and amended. And particularly, I told you about the Intergovernmental Fiscal Arrangement Act and NNRFC Act. That is very important to revise them. Second, it's like a judicial institution. Many countries, even in India, since 1970, Supreme Court has interpreted federalism in a very liberal term, very progressive term. And as you know, I was chief attorney and I was also heading the law drafting committee of the Madhesh province, from where the voice for federalism came very strongly. And there I drafted around 60 laws in my committee, including at that time Police Act, Civil Service Act, and there was a direct call from the Prime Minister from the Kathmandu, no, you can't do that. Let the central government to write first. And we crossed the line. Even at that time, Prime Minister Prachanda publicly said, you are crossing the line. So you can understand that political background. But we went to the court and challenged in 6 cases, very important cases. We already asked to amend ultra vires for this Intergovernmental Fiscal Arrangement Act. But all these 6 cases except one, we challenged. There was a Sagarnath forest, national forest, and it was like the central cabinet decided to keep it in the center, and the constitution says that it comes to the provincial jurisdiction. We challenged it and we got the stay order, and the case has not decided yet last 6 years. So even single case has not decided by the constitutional bench of the Supreme Court. So we have to look at these aspects as well. And now I would also like to add in this paper the practices. I think most of the voice and opinion made about federalism, it's very Kathmandu centric, and most of the people who make comment is like they have not crossed Kalanki, in my opinion. They have not visited the rural area of Tarai. You come, you can easily compare that at least roads are built there. at least roads are built in all the areas, which you cannot, like in 250 years, they were there, mud in every village. So some changes have been made there, but we have not been able to see those positive changes there. The people now, they don't need to travel to protest to come to the Maitigar always. They can protest now in Janakpur. So their costs are also minimized. So all the political arrangements have been made there very easily. They can come in by the cycle within 30 minutes and meet the chief minister and show their grievances, which was unlikely in the past. So I think we have to look these aspects and have to be included in this paper. In Indonesia, I don't have much to comment, because he has already mentioned, and his paper also mentioned, that this is unitary country, but at least in two states, in Papua and Aceh, they have some kind of regional autonomy, in a way that because of the background of the conflict background, they have assured those kind of autonomy as well. So yes, the time has, I am commentator, I cannot use more time, but in the last, I would like to add 3-4 points from my sides. One things, we have to, particularly in South Asian trend, what I could say that we cannot isolate the fiscal federalism with the political backgrounds. Even in Pakistan, it's army takeover and highly centralized with the change of the army leadership in the power. In Nepal also, it's like, it's not similar, but to some extent, we have to look that we have new federalism, it's a baby federalism, and the federalism is Nepal. Basically, it's like an unwanted baby for the policymaker, for the bureaucracy, for the media, for the leadership here. They have to nurture, they have to take care of baby, which they never imagine, basically. So but we are pushing for implementation in this context. So definitely there is a very negative trend to comment without looking at the result. Some positive change. I'm sure the chief minister, with whom I worked for last 5 years, he came yesterday and talked a lot of things here about his experience, about the question I saw there about a bicycle. Of course, we started, the first target we made is a reform on the gender laws. We have 50% reservation in Madhesh province, which none of the state has right now. 50% in civil service, in security, in all the state apparatus. In Kathmandu, you have 33%. This was the new practice there. We have made new things that any girl born in Madhesh province would get 3 lakhs insurance immediately after, because it was taken that the girl born with the economic hardship burden for our family. So we try to change those things, but those things have never been analyzed, seen, and recognized in Kathmandu. So I see not landlocked country, but mind-locked as well, because many positive things have not been recognized here. But within 5 years, within 7 years, I can say a lot of changes have been made. With all these actors, main actors in Kathmandu, they don't want federalism, they don't want to implement the federalism, they don't like the federalism. Despite that, these changes have been made. So what I mean to say that, let's look at the political background, let's change the legal setups, institutional setup. We have to somehow push up the judiciary as well to look on those cases, at least 5-6 cases they could decide and set the principle of federalism, but they are not deciding since the last 6 years. So those things are very important in my opinion. Thank you very much. My time has finished. Sorry for 2 minutes more. Thank you.
Thank you very much. Now on to Professor Muhammad Rizwanul Islam of Department of Law, North South University, Bangladesh.
Thank you, Mr. Chair. First, let me thank Professor Odhikari for the very kind invitation to come here as a commentator and to learn from the great papers that have been presented since yesterday. I have learned quite a lot. And also, many thanks to all the organizers for their very warm hospitality. Now, I would have to make the comments with a lot of caveats and I would say humility, because of my very limited knowledge of Nepalese constitutional journey or Nepal federalism journey. The point that I take from Professor Giri's paper is that, and I have had the pleasure of going through his written paper, although very quickly, not a very, I would say, thorough read, but on a very quick read, I could see that there is a very thorough analysis of the theoretical findings of his, theoretical underpinnings of his paper, that how there is a subtle economic vision interwoven in the current constitution of Nepal of 2015. And for the interest of time, I think he hasn't gone on to make those theoretical points, and I would also not dwell on them. But if I move to the a more, I would say, practical points that he mentioned in his paper and also in his deliberation this afternoon, that I would say law is always the outcome of a political process, as my fellow commentator has very nicely mentioned it. So as that economic underpinning is there in Nepalese current constitution, I think law or words can have its own life. So once those words are there, yes, as I gather from the presentations from yesterday and also some from today, that there is some sort of dissatisfaction with the slow pace of some federal issues being dealt by the Nepalese constitutional bench, the Supreme Court's constitutional bench. But as long as those words are there, as long as some lawyers, some politicians, many of you in this room, you take those issues to the court and you create the right incentive, as mentioned by Professor Giri, for the court to intervene, I'm sure there would be a day, sooner or later, where those moot words in the Constitution would have its application in actual court cases. I cannot say when or precisely how, but I would say the people in this room, the academics, the politicians, members of the civil society, the journalists, as the privileged sections of the community, we have a role to ensure that the court is playing its role in due course. As a student of law, I have some reservations about judiciary being overactive, particularly in, if I may bring in some Bangladeshi examples here. In my understanding, our Supreme Court, particularly in its writ jurisdiction, in some cases have passed some directives which I qualify as quasi-legislative directives. Directives where it has in effect instructed the parliament that do this or that. As a student of law, and I was a firm believer in separation of powers in the three organs of the state, I'm not a very keen supporter of those sort of directives from our Supreme Court. And through my writings, through several articles and book chapters, I have tried to explain why. But when it comes to federal disputes, and in many other cases of interpreting the constitutional provisions, I would have a much more differential, I would expect a much more invasive or differential role from the Supreme Court, being the constitutional court, having the role to interpret the Constitution. Why? Because of the very fact that when it comes to federal disputes, in my understanding, these are disputes between political actors. So by nature, these disputes will involve intricate political questions. So even if they may have political ramifications, they may have political sensitivities, in my understanding, I would submit that the Supreme Court cannot be conservative in dealing with these questions, because this is the very function for which, in my view, the Supreme Court exists, or for that matter, any court exists, to settle disputes. So when it comes to federal disputes, be it fiscal or in other matters, the Supreme Court has to play its due role. And I would borrow from another colleague, another presenter who presented yesterday, Professor Tasneem from Pakistan. She made a poignant point, in my view, that the journey of federalism in early years, in maybe 18th century, 19th century, it was almost entirely state-centric. Whereas in last 5 decades or so, as she mentions, it is moving more towards the people-centric direction. And if it has to do so, the Supreme Court has to play its due role as delineated in the Constitution. And as I already mentioned, it is Supreme Court being an actor which is, at least in theory, an apolitical actor, although in my belief it is not. In any country, the court can be completely free of politics, particularly the Supreme Court, when it has to deal with so many constitutional issues, which has intricate political issues involved in the matter at hand. But even being so, if it has to be incentivized, then the push has to come from the politicians, from the privileged sections of the community, those of us perhaps who are sitting in this room. Now, if I may move to the second presenter, like my fellow esteemed commentator, I would not have much to say on that, particularly because my knowledge about Indonesian constitutional journey is even much less, and also because I think he was arguing in a way of a sort of asymmetric decentralization in a very unitary state. And rightly or wrongly, I could sense that there is an implicit message, at least from the title and abstract of his paper, that somehow that model may be offering some lessons for Nepal. With due respect, I would humbly suggest, if that was the intended message, that the Nepalese constitutional journey has its strong political background. And this is a constitution, I mean the 2015 constitution, as I understand it, is the outcome of people's direct choice. People voted for this constitution. Yes, the driving force, as I understand from some literature that I have digested in the last couple of days, that the driving force may have been from the Madhesh province, or maybe from some political parties, maybe particularly from Nepalese Communist Party. But the Nepalese current constitution has very direct backing from the people of Nepal. The Constituent Assembly was directly empowered by the people to draft the constitution. So I'm not entirely sure that going back to any sort of unitary model would really be an option for Nepal in the near future. I may have gotten his message horribly wrong. I'm not entirely sure if that was an implicit message from Professor Satya's paper, but that's what I got from his abstract or the presentation that I heard. With that note, thank you all for your time, and thank you for bearing with my broken voice. Thank you all.
Thank you all the speakers. I mean, you're a great speaker. I mean, everybody kept on time. We have all of the allocated time for the question and answer. But the only limit I'll put is at times we tend to make statements which are longer than, which last longer than 2 minutes, and every question has only 2 minutes allocated. So I mean, if we can, for the interest of greater discussion, discussion in depth, if you first pose the question and then substantiate your question with a statement, that will be very good. So I mean, can I see hands? I mean, if there are more than 6, I cannot. Then rest will have to follow the speakers to the lunch. Okay, 1 there, 2, 3. What I will try to do is, since I was there this morning also, I would first pick the ones who have not gotten a chance to ask a question earlier. Okay, oh, right there, last table, I believe. Yeah.
धन्यवाद। नमस्कार, म नेपालीमा बोल्छु। म अमित उप्रेती, सरकारी वकिल, र मेरो प्रश्न चाहिँ अब अहिलेको पेपर प्रेजेन्टर र दिपेन्द्र झालाई हो। उहाँहरू दुवैजना अब लिगल ब्याकग्राउन्डबाटै आउनुभएको भए पनि मेरो क्वेसन चाहिँ अलिकति यो हाम्रो नेपालमा चाहिँ डिस्कोर्समा अलिक प्रोडक्टिभिटीको पर्सपेक्टिभबाट चाहिँ हामीले संहितालाई हेरेका छैनौँ। त्यो पेपरले पनि इकोनोमिक एनालिसिस अफ लमा ल्याएको छ। जस्तो हाम्रो दलित आयोग छ, मधेसी आयोग छ, प्रदेशहरू पनि एकदम देखाउने दाँत मात्रै भइरहेछन् क्या अहिले। त्यस कारणले अहिले हाम्रो संहिता पनि रहोस्, चुस्त संहिता रहोस् र इकोनोमिक रूपमा इफिसियन्ट पनि होस् को लागि के गर्नुपर्छ, संवैधानिक रूपमा यी परिवर्तनै गर्नुपर्ने छ भने चाहिँ अलिक फङ्सनल एस्पेक्टमा पनि इकोनोमिक आर्थिक रूपमा पनि भार नहोस् र संहिता पनि अलिक सबल खालको संहिता नेपालमा रहोस् भन्नको लागि यो दुवै पर्सपेक्टिभबाट हेर्नको लागि चाहिँ के गर्नुपर्छ, चाहे त्यो संविधानमै परिवर्तन गर्नुपर्ने छ कि भन्ने।
Anybody who would like to ask a question? I'll go to Dr. Karna.
Thank you, Dr. Rijal. It's nice hearing some experts. I go through the paper, Professor Shiv Kumar Giri. Professor, I have some question that when I go through the paper, your paper, I couldn't find the economic analysis. I mean that the tax regime, the share of the tax between the province and central government, and the organization which is supposed to analyze about that NNRFC. It's a very long name. Juddiji is the member of that commission. So the one thing, second thing that I could find that the political aspects of the federalism in Nepal. Just to remind you that 140 people of Tarai Madhesh sacrificed their life for federalism. And it has been noted that there was two statements by the Prime Minister with the 7 party leaders. The first by the Prime Minister Girija Prasad Koran and Constitution amended. The one thing. Second thing, just to suggest you that there is a book, an economic interpretation of the US Constitution by the Charles Shepard, which is a very popular book, and analyze how in the very beginning US Constitution has been, how the economic interpretation and how the province, I mean the states of the America. And there are a lot of books written on the Indian tax on that way. So I think that this paper lacks the tax and how the sustainability of the province is. So that much.
Thank you very much.
Thank
I
you.
have seen 3 hands raised. I can either go to him, but I am still waiting for other hands because I've seen him speak in the earlier session also. If I do not see any other hand, then I'll go to him.
Yeah, thank you. My question is for Professor Satya. Professor Satya, can you tell us a little bit more about the power, responsibility of mayors and governors in Indonesia? The power and responsibility of mayor and governors. Because power and responsibility of mayor and governor, because it seems that they have quite a platform. Your current president is a former mayor, and two of the candidates for next year's presidential election are either governor or former governor. So they have quite a bigger platform. But which power do they have? Thank you.
Thank you very much. I also follow my predecessor. Stop at 3 and then give a chance to the speakers to comment on them, and then I come back to other questions. Who would like to go first?
Thank you very much. I would like to address the question being asked as the first question. What should we do to make it more viable so that people can accept to welcome the federalism in Nepal? Definitely, I don't have a blueprint or formula that I could produce here or show you here, but at least I could recommend few things. First thing, definitely is a parliamentary development fund. The Supreme Court has already stayed on that, and that's a welcoming step in my opinion, because I saw that, okay, every MLA and MP thinking that I have 5 crore in my pocket and I can spend it at any places that I want, basically. And there was huge corruption with that. So I think that's very important step, and it should be continued in my opinion. Otherwise, if an MLA or MP enjoys for 5 years, it means 25 crores, then the poor family member cannot compete in election with them. So that's very welcome in my opinion. Second thing I could recommend, I think same
kind of like using state resources for personal benefit. Same formula of Singhadarbar has been copied in Janakpur and in local body as well. Because if you see the speaker in province, 2 car front, 2 car back with escorts. Like if you see the chair of the committee of the Legislative Assembly, you see that lot of benefits and privileges has been given to them, resources. So like it's like a getting lot of resources for individual benefits. I think that has to be amended, that has to be improved, because the people see the government from very nearby and they see that in the village, okay, one MLA come with 4 cars with this type of security forces, they get irritated because their life have not been changed yet. So I think improvement there, like not copying the same thing, but simple living, I think like people should realize, okay, I'm coming just. So this, I think this should be improved. Third, I think federalism, particularly the mid structure, the provincial structure has not been linked much with the daily life of the people. Like there is no linkage between daily life, like peace, security, or any kind of delivery. So I think that we should find a way. Last, not the least. Okay, just last, what I would say, we have to revise the unnecessary institutional burden and their economic burden on people, tax, particularly all these bullshit constitutional body, which has nothing to do, in my opinion, and constitutional body. They are just enjoying the resources without nothing. Oh, thank you very much.
Thank you very much. Now, Professor Arinanto.
Thank you very much. Yeah, as I already explained that the governor actually is it has 2 positions. First is the vice of the central government in the regions, and secondly, of course, he is the head of the province. Yeah, and then the mayors or regions. Yeah, also subsequently head of the regencies or municipalities. So that there is a idea that in the future we only elect mayor or region, and the governor could be appointed by the central government, and the power it's quite wide. Yeah, almost all power to implement the regional government authorities. Yeah, except the power of the central government, like foreign policy, yeah, and then security and other power in the central government. That's in short. Thank you very much.
Thank you. Now on to Professor Giri.
I'll try to be as short as possible. So I have 3 questions asked. Okay, one also related to comment made by Advocate Dipendra Jhaji about political aspect. Actually, my paper and my perspective is not ruling out any political, cultural, social perspective. It is just offering one extra perspective to see things. So if you have political perspective, okay, fine, a lot have been written, and we cannot overlook, of course, sometimes economics cannot offer solution. You have to make hard political choice. Being educated in Canada, I have seen the friction, several states, they have their, even, Canada has more than 200 years history of implementing federalism, but still there are problems. So politics is not going to go anywhere. The argument is, let us have one more extra perspective. Maybe if you cannot solve the problem politically, maybe your decision informed by economic consideration offer, alternative, better solution. So that I want to say. So politics is not going to go anywhere. Culture is not going to go anywhere. The question about productivity, actually this is what the paper tried to say. Like let us say, I want to bring one example. Like if province is given, let us say, responsibility regarding forests, and you are not giving even a single forest to that province, what kind of productivity? I mean, even if it is a political choice, very bad choice, very inefficient choice. So surprising, in Nepal, I asked this question to Honorable former Chief Minister of Madhesh province yesterday. Every government property belongs to federal government. and where the provincial governments are going to implement their policies. I mean, if you look into the other federal countries, they the federal government has to negotiate with the provincial government or state government to have certain federal properties. All property belongs to provinces or states. US, Canada, same thing. So that is what I want to say. And the last, yeah. Okay. The last one about John Baird's book. Actually, I have read that book written 100 years ago. But, and he actually initiated the idea of economic constitution. But it is criticized very much, saying that it's a Marxist notion. So, yeah. So the last thing is, actually I follow, modern economics lawyers like, let us say, Robert Cooter, Richard Posner, Stephen Voigt, etc. Thank you.
Now, I go back to the gentleman there. Please, time is of essence. That you have realized already, I guess.
I just have a very quick comment as such, and this is something relates to what I think Mr. Giri and Mr. Rizwan also mentioned. In the context of, say, the involvement of the Supreme Court of India in the strengthening of federalism, I mean, it's not a specific, it's just a third perspective which I want to offer to the two different views taken. The Supreme Court initially took the view that Mr. Rizwan said, which is that this is a political issue, we don't want to get into it. But they also realized this is a constitutional issue somewhere in the 80s. So the case, I think, which Mr. Giri referred to, which is the Bommai case, where the Supreme Court said we will limit the power of the union government to dismiss state governments. Earlier in the 70s, they had said we're not going to get into it. So in the 90s, when this changed, there was a very conscious judicial choice that this is an arena we have to step into because the Constitution's framework is being affected. But, and I will also add to the point that I think Mr. Jha mentioned, we have to understand both the judicial and the political developments which led to this situation. It wasn't just the judiciary strengthening federalism. There was a much greater understanding of federalism in India, which happened, I think, in the 70s and mostly in the 80s, which led to the changes that we saw in the 90s. And one of the interesting things is, even though you have a much stronger one-party government at the union level, the federal structure of the constitution still remains robust. Maybe there are some small issues, but that federal structure, which is a mix of politics, judicial, and as I will discuss in the next session, fiscal aspect also, they have remained robust. So I just wanted to add that comment to the discussion.
म प्रमोद पोखरेल गाउँपालिका राष्ट्रिय महासङ्घबाट प्रतिनिधित्व गर्छु, फेरि पनि परिचय दिएँ र अघि एउटा कार्यपत्रमा एउटा कुरा उठ्यो कि यो सङ्घीयतामा जानु पूर्व सामाजिक भौगोलिक र राजनीतिक हिसाबले मात्रै सङ्घीयतालाई बुझियो र वित्तीय हिसाबले सङ्घीयतालाई बुझ्न सकिएन। त्यही कारणले अहिले तपाईको चाहिँ केन्द्रीकृत शासन प्रणाली तलसम्म अधिकार प्रत्यायोजन गर्न समस्या भएको छ भन्ने टाइपले चाहिँ कार्यपत्र प्रस्तुताले राख्नुभयो र यो हिसाबले तपाईको चाहिँ जुन हामीले हरेक वर्ष हामीले बजेट ल्याउँदाखेरि बजेटमा नीति तथा कार्यक्रम ल्याउँदाखेरि हामीले के भन्छ भने गरिब, दलित, महिला, पिछाडिएका वर्ग, समुदायको तपाईको जनलाई मुख्य प्राथमिकतामा राखेर बजेट बनाउने र त्यसको नीति तथा कार्यक्रम गर्ने गरेर कुराकानी, भाषण, भिषण, फोरमहरुमा गर्ने गर्छौं। तर व्यवहारता के देखिन्छ भन्नुहुन्छ भने जो प्रधानमन्त्री भयो, जो अर्थमन्त्री भयो, जो मन्त्री भयो, उसको गृह जिल्लामा प्रशस्त बजेट जाने अघि पनि कुरा आएको थियो र दूरदराजका जहाँ त्यो समुदायले प्रतिनिधित्व गरेर चाहिँ बसेको छ, त्यो समुदाय बसेको छ, त्यो ठाउँमा तपाईको चाहिँ नगण्य मात्रामा बजेट नहाली नहुने, अब्सेन्ट गर्नै नमिल्ने भए चाहिँ बजेट जाने, अन्यथा तपाईको चाहिँ बजेट जाने अवस्था नहुने र यसले गर्दाखेरि यो वित्तीय क्षेत्रकै कारणले, वित्तीय हिसाबले तपाईको स्रोत बाँडफाँडकै समस्याको कारणले संघीयतामाथि धेरै प्रश्नहरू उठेका छन् र यो विषयमा चाहिँ खास कुरा के हो, समस्या यही मात्र हो कि यो बाहेक अरू पनि हो? मेरो तपाईको चाहिँ यो प्रश्नको उत्तर दिपेन्द्र झा र तपाईको चाहिँ डाक्टर गिरीलाई चाहिँ मेरो प्रश्नको जिज्ञासा मेटाइदिनु हुन म अनुरोध गर्छु।
Thank you very much, Professor Ko. I come back to you. I didn't see the hand before, so I certainly will take the seventh question.
A very quick comment. Thank you for Dr. Rizal, Islam, and the gentleman comment. In Malaysia, the Supreme Court or Federal Court has always been placed with the task of whether an issue is justiciable, therefore being thrown into a political thicket of many issues. But I do agree that this is because political actors themselves abdicate the realm and do not come to terms with seeking a proper consensus, and they throw it to the courts. Then the courts take on what I would call a moral legitimacy in ruling. But as usual, they are then faced with deep issues of how do they approach interpreting the constitutional norms. Just this morning, I got a news from Malaysia that vernacular schools are held to be constitutional, despite the challenge from ethno-religious linguistic groups that they should be unconstitutional. So we are into the realm of interpretive politics of constitution, the hermeneutics of why judicial arrangement would come to a certain landing. I very much would elicit a comment from Dr. Islam on this. Thank you.
My name is Sarah Tamang. I'm affiliated to Martin Zotari. My question is to Professor Arinanto, but it's catalyzed by the excellent comment by Dipendra on the need to change perspectives and to look beyond the state-centered point of view and perspective. And it's also catalyzed by the need to go beyond just a lot of this legal framework and constitutional stuff that we hear about into the realm of ideas, because ideas are very important in how we constructed a federal structure. And so my question to Professor Arinanto is this. In Nepal, there's a big differentiation, continuing differentiation between those who advocate for certain rights of indigenous peoples and Madheshi peoples in the realm of social justice, which you mentioned, and the idea that certain demands by the historically excluded are actually against national interests, are against sovereignty, are against development. It's bikas birodi to ask for certain rights. So here the struggle for implementing a proper federalism for the rights of all conflicts at the realm of ideas. Do you see where I'm going with this? And so I'm wondering whether in Aceh, in those kinds of debates that happened during the peace process and now, is there a differentiation that you can see, that there are different continuing perspectives at that level of maybe of Aceh and other indigenous people, and the national narrative of, you know, what is development, what is needed for national identity and national security?
Thank you. To now the speakers, each of you, I can only give 2 minutes. I start with you, Professor.
Thank you, Professor Ko, for your excellent question. Well, with regard to issues like this, where there are lots of value questions, yes, some might say that the court is not the best forum. But I would say that as long as it reaches the court, and it reaches the court, as I think you have pointed out, that because there is no political consensus, I would say that if I can take a sort of hypothetical example, that if we were told that lunch would be served at noon. Now, what noon means, it has to be left to the court. Some of us, if you are too hungry, we might be unhappy if the court says that the noon is at 2 p.m. Some of us, if we have a habit of taking late breakfast, we may be very happy with that. So if I may answer your question, that yes, in issues like this, there will always be some value questions that perhaps is better left to political actors than judicial actors. But if it reaches the court, then there are settled norms of interpreting texts. So as long as the court is consistently applying those settled constitutional norms and norms of interpretation, I'm happy with that. If in particular cases they do something which is politically unpalatable, then I think it is always up to the politicians to nullify those, to go back to the drawing board, to make new laws or constitutional amendments within the constitutional scheme. Thank you.
Thank you very much. प्रमोदजीले नेपालीमा सोधे, मैले नेपालीमा एड्रेस गर्छु. डेफिनेटली यो त म त के भन्छु भने यो वित्तीय हिसाबले नबुझिएको मात्र होइन, राजनीति हिसाबले पनि बुझिएको छैन भने मेरो बुझाइ हो. संहितालाई राजनीति हिसाबले पनि बुझिएको छैन. मागेको थियो, दिएँ. अब यसलाई चाहिँ कसरी बिगार्ने, कसैले भत्काउने, कसरी कमजोर गर्ने र फेरि त्यति मात्रै सोध्छ पोलिटिकल लेभलमा पनि भन्ने मलाई लाग्छ. र डेफिनेटली तपाईँले भनेको कुरामा म के सहमत छु भने प्रादेशिक लेभलमा पनि त्यहाँको दलित, त्यहाँको जनजाति, त्यहाँको पछाडि वर्गलाई कसरी अगाडि ल्याउने भन्दा पनि त्यहाँको सर्टेन ग्रुपले मात्रै हेजिमोनी मेन्टेन गरेको कुरामा पनि मैले दुई मत राख्दिनँ। त्यस कारणले दुईटै कुरा करेक्ट छ भन्ने मलाई लाग्छ। म हजुरको कुरामा यति मात्रै कमेन्ट गरेँ, 2 मिनट्स छ। शेराजीको कुरामा डेफिनेटली Madhesh province is taken as a like a, when we assert for giving, because law and order is clearly mentioned in the jurisdiction of provincial government, and when we made Police Act, when we say now the Chief Minister of Madhesh province given a memo to the Prime Minister with 30-day ultimatum to hand over police. I don't think Prime Minister is going to hand over the police, because they think that okay, if we give police to the, particularly for Madhesh province, they are always protesting, and if they have 10,000 police, what's going to happen to our national integrity and security? So those kind of perspective is still like there's trust deficit, particularly on one province, which made on the identity basis, basically. So that's the problem we have, and I think it's a long way to go to change that perspective, in my opinion. Thank you.
मैले पनि यो प्रश्न म प्रति डाइरेक्ट भएको चाहिँ नेपालीमै भयो हुनाले नेपालीमै उत्तर दिने कोसिस गर्छु। यो कहिलेकाहीँ के समस्या हुने रहेछ भने म अहिले उदाहरण फेरि भारतकै उदाहरण दिएँ। भारतको सङ्घीय संरचनामा दिल्लीको बडा अनौठो त्यो छ। अब स्टेट भनेर चिफ मिनिस्टर पनि छन्, तर पावर सेन्ट्रलले राखेको छ, त्यहाँ अहिले पनि झगडा। तर पिपुलको पछाडि ब्याकिङ सपोर्ट भयो भनेदेखि त्यो यो इकोनोमिक्स थ्योरीले पनि भन्छ, देयर इज अ बार्गेन थ्योरी। तपाईँले बार्गेन स्ट्रेन्थेन गर्नु पऱ्यो, केही सर्टेन इनोभेटिभ आइडिया तपाईँले डेभलप गर्नु भने त्यो सजिलो हुन्छ। जस्तो मलाई के लाग्छ भने अहिले प्रोभिन्सहरूले पनि र स्थानीय निकायले पनि पहिला चाहिँ आफ्नो त्यो खर्च छ नि, आफ्नो चाहिँ नि क्षमता अभिवृद्धिमा लाग्नु पऱ्यो। बार्गेन गर्नु पनि सकिने भयो। त्यो जुन काम फेडरलले गरिरहेछ, इनइफिसियन्टली गरिरहेछ, त्यो काम हामी इफिसियन्टली गर्न सक्छौँ भनेर एउटा इक्जाम्पल देखिने बित्तिकै पिपुलले पनि सपोर्ट गर्न सुरु गर्छ, तपाईँको बार्गेनिङ पावर पनि बढ्छ। खालि मलाई पैसा मात्र चाहियो भनिरह्यो भने अब पिपुलसित कट अफ भयो भने तपाईँको बार्गेनिङ चाहिँ त्यो उसको के भन्छ एक कानले सुन्छ अर्को कानले उडाइदिन्छ। अब अरविन्द केजरीवालको हेर्नु न किन उसले बार्गेन गर्न सकिरहेछ भने बिकज देयर इज पिपुल बिहाइन्ड हिम। त्यो चाहिँ एउटा इनोभेटिभ हुनु पर्यो, कसरी चाहिँ ट्याली गर्ने भने। अनि यो कुरा फेरि इकोनोमिक्सले सिकाउँछ बार्गेन थ्योरीमा, हाउ यु इन्हान्स योर क्यापासिटी टु बार्गेन विथ द फेडरल गभर्मेन्ट। बार्गेनिङ त चलि नै रहन्छ। यति म प्रति डाइरेक्ट भएको सायद यही जस्तो लाग्छ। धन्यवाद।
Thank you very much. Now on to Professor Arinanto.
Thank you for sharing your experience in Nepal. I think the conflict in the field of equitable distribution of fiscal and state resources happen everywhere in the world, yeah. So I think we try to find a way how to solve, yeah, especially for two provinces actually, only Aceh and Papua. For Jogja, it was given the status of special features because historically Jogja was a big kingdom. And when we get our independence on 17 August in 1935, Jogja already stated that they will join the unitary state of Indonesia, so that we give the status of special features. That's not because of the conflict. But Aceh and Papua, this is one of the problem, yeah, in Indonesia, so that we in some area we give like please you get more, yeah, because of the historical conflicts, yeah, like as I said before, you could see in on page 12 on my paper, number 4, and a point in the MOU Helsinki, for example, Aceh is entitled to retain 70% of the revenues from all current and future hydrocarbon deposit and other natural resources in the territory of Aceh, as well as in the territorial sea surrounding Aceh. This is what I said, that this is an equitable distribution for the central government, because central government must also protect all 38 provinces, I mean. But Aceh itself, they want 70%. But because of the historical reason, they agree to stay in the unitary state, yeah. and not separate from Republic of Indonesia. And now there is no more conflict in this field. Yeah. In Papua, there is still conflict, but I think it's different reason. Not because they already guaranteed by law. Yeah. Only security conflict now in Papua. Yeah, I know about this because I involved also in drafting some of the laws, these laws. Yeah, these 3 laws. I also drafting these laws before, so I know why this article become like this, or what is the reason behind this article, yeah, or the legal policy of the articles. That's what we try to do to maintain the unitary state of Republic of Indonesia. Thank you very much.
Thank you very much. We had wonderful panel, and the reason I was very particular about time was 2 reasons. One, we're already late for lunch, and second, I've been allocated 5 minutes to wrap it up at the end of the session. Had I given you more time, I would have lost mine. And any minute that I could save, I could utilize that for myself. Let me just, I don't need to really wrap up what's been said. I mean, they were very eloquent in what they said. Questions were very, very pointed. So the answers also were equally pointed. So, and then again, I mean, if there is anything that we disagree on that, we can carry the conversation into our lunch. And I gather there is a reception in the evening also. Anything that we cannot settle in during lunch can be taken to the reception in the evening. It will be even more interesting then. After a long time, I can say things I would love to say and afford to be politically incorrect. I used to be a member of parliament for 16 years. Thanks and no thanks to my party leadership that I am not a member of parliament now. So I can afford to be politically incorrect. One of the things I feel very strongly about is when we did federalize our country. A lot of us would like to take cues from the US federalism or Swiss federalism. US tried to create more perfect union. Our story was not to create more perfect union. Swiss is entirely different thing. Ours, when we were trying to federalize our nation, what we were trying to do was, if we remember our discussion back then, we're thinking about identity based on caste, ethnicity, and then slowly we inserted certain geographical areas as an identity group also. We're not worried too much about anything else. We didn't talk about fiscal federalism much. What we basically thought was, if I see at the top of the table, among the ones who make policy in the country, in the province, if I see faces just like mine, I should be okay. Now we've come to realize that that's not enough. That's just the beginning, a very humble beginning. That's who we are today. So if somebody says we've not made progress in federalism, I simply disagree. We've made tremendous progress. Tremendous progress, because these are the teething problems from the step of creating states. From a unitary country, we had no, we didn't come together. We're one, and then we basically, what we're trying to do is create states so that people will feel belong to this nation. People will feel that there is no reason why we should be separate from the entire entity that had been there for like 250 years. We have achieved that. Though still there are people, political parties, who think that we still need to federalize more, not in the sense of giving resources to the provinces and the local bodies, but in the sense of creating more states. I do not know how justified that argument is, but I would rather concentrate more on strengthening what we already have, making them work better, and making them deliver to what people have expected from them. That has not happened yet. There is across the board, there is frustration out there in the country with the national political parties, and I feel bad to say this, with the political parties in Madhesh also, the ones which has been active for like last 15 years. And then there's so much that could be blamed for, and punching bag because of people like me, people who hail from hills, migrated to the plains, have their mother tongue. The mother tongue is Nepali, and what we have started articulating is it's all because of federalism that the country is not functioning, and that is not it. That is not it. People are simply trying to put all the blames on federalism. Now it's time for us to go through what we try to federalize. We try to create a government, which we have not been able to do yet. Let's try to create a government that can understand people's aspirations and can put its stacks together to start delivering. For this term, we have 4 years still, and local governments, states, and the central government, if we can put our acts together, will save the Constitution, will move the country in the direction people did aspire for when they came out in such a large masses during the people's movement. If we cannot, then who knows? Our Constitution could be history. But I would like to believe that we can make it work, because lot has been already spent. For more than 75 years, we have tried to create a nation that can rise up to the challenges that we face. I guess we can all do that. Let's be wiser enough, not only in political sides. We can very easily blame politicians. I could do that because now I'm not a member of parliament or a minister. Back then I used to be. But that's not going to solve our problem. We all are to be blamed. We cannot create a nation wiser than what we are as people. I'll end there. Thank you very much.